I'm going to introduce our first speaker, Luke Clements, who's Cerebra Professor of Law and Social Justice at the School of Law in Leeds. And his academic research has been around the rights of people who experience social exclusion, including disabled people and their carers. So he is a real expert on litigation in this area. He's helped draft and promote a number of parliamentary bills aimed at improving the rights of people experiencing social exclusion, including bills that became the Carers Recognition and Services Act in 1995 and Carers Equal Opportunity Act in 2004. And I'm very pleased to hand over to him now.
Thanks very much, Hilary. Thank you, everybody. Run a research unit at the School of Law at Leeds, funded by a disabled children's charity called Cerebra, who are very interested in problem solving for families with disabled children, how they can access their legal rights, which are pretty good, actually, if you know what your rights are. But if you don't have a sister who's a barrister or you don't have those sort of networks. So we're particularly interested in those issues and those groups. And we publish every year lots of reports on commonly occurring problems. This is slightly offbeat, although I've written a major book on the Care Act, and I was the advisor to Parliament on that bill that became the Care Act. This particular area is sort of, I feel slightly on thin ice, because I'm amongst people who really know probably a great deal more. And I'm sorry if I'm going to repeat some of the stuff that is elementary. So I was sort of trying to work out where all this came from. David just talked about this six individual issue. And so I sort of labeled this human rights, dogma, domestic law, village and intentional communities. I'm going to start sort of international level and then come down to domestic legal level. I'm going to be talking about English law, although in this respect, Welsh law is virtually identical. Social Services and Wellbeing, Wales Act rather than the Care Act, but in this context are the same. But I can start internationally and sort of try and say, where in the law does this small community stuff come? Now, in international human rights, there's all sorts of rights concerning this particular topic, but most obviously is the European Convention on Human Rights, which is about liberty. And David's talked about ATUs, about people being actually forcibly detained, which is under Article 5 of the European Convention. That's what regulates it. But we're much more interested, I think, today in Article 8, which is the right of families to respect for their private and family life and their homes. And Article 8 is a sort of pretty important provision because it says there's a duty to respect private and family and life and home. But we ratified that convention in 1950, and it's now part of UK law, as you all probably know, under the Human Rights Act. But there's this other thing that's come along, which I think is really where the trouble sets in. I mean, it's a tremendous piece of international legislation, but it's the UN Convention on the Rights of Persons with Disabilities. We normally refer to it as the CRPD. So it's an international convention by the UN, and this bit of the UN is based in Geneva, and in 2007 the Foreign Secretary went over. I can't remember who the Foreign Secretary was in 2007, but he or she will have ratified this, signed it, and said that we promise that these rights detailed in this convention will be respected in the UK. We've never brought it into domestic law, so it's very difficult in court to mention this convention because the judges will say it's not part of domestic law. But it does have an influence because the UK did make this promise that it would do its best to respect those rights. And the key right there is Article 19, the right to independent living. It actually says living independently and being included in the community. And the convention is fleshed out by a general comment that the committee based in Geneva of experts, all of whom are disabled people, issued in 2017. What I have to say is that the convention is something that we've signed up to. we didn't sign up to the general comment. This is something that's come along later. It's a sort of amalgam of what's called country report ideas. And there are aspects in the general comment, not just on this particular provision, Article 19, but other provisions that are troubling academics and, I think, practitioners. So Article 19 is about the right to live independently in the community. It has three aspects. One is broadly called deinstitutionalization, getting rid of the mental handicap hospitals, the mental hospitals, and also the psychogeriatric wards that littered general hospitals 35, 40 years ago. So the first bit is about getting rid of big institutions where dreadful things have happened in the past. The second bit is a duty on the state to provide really good quality domiciliary care support services, personal assistance services. So that's a state obligation. And that's really where I spend most of my time, looking at the obligations on the state to provide, support to families so that they can overcome the barriers that their disabled child or who they care for are experiencing, the social model of disability stuff. And the third element of this is that all other services in the community should be accessible. So transport and bank machines and all of those things. So you have those three things: get rid of institutions, get rid of that issue, produce really good quality domiciliary care services, and make everything else acceptable. Really brilliantly worded document. I'm only interested today in that little bit A, which is persons with disabilities have the opportunity to choose the place of residence where and with whom they live on an equal basis with others, and are not obliged to live in a particular living arrangement. And I don't think anybody here would have a problem with that. That seems to be the heart of the point. The general comment then fleshes that out, and it defines independent living as individuals with disabilities are provided with all the necessary means enabling to exercise choice and control over their lives and make all decisions concerning their lives. Independent living is an essential part of the individual's autonomy and freedom and does not necessarily mean living alone. So again, we could be on the same page there. There are problems. I'm talking about dogma quickly today, but I'm also talking about ambiguity. And one of those ambiguity words is autonomy. And I'll come back to that. David was saying it's all about choice. Well, choice is a really difficult word too. And autonomy is a particularly difficult word. And what do we mean by autonomy? And I'll come back to that. And I think that this is where the UN committee, with great respect, has gone off the rails a bit. And then the general comment flashes out this, saying that it doesn't like institutional settings, which is quite right. I was part of a big push to close institutions in the Balkans, Central and Eastern Europe. And a lot of these very big institutions were closed, but they just sort of metastasized basically as mini institutions all over the place. And that individual support didn't exist. And I can well understand, I think we can all well understand that isn't desirable. And so it has this long list here, and I'm not going to go through that because I want to open up, but there's really nothing there either that I think we would disagree with. It's utopian. It's not going to happen even in the most developed countries like the UK. But these are, I think, noble aims. And if there's anything there that somebody wants to pick up, please do so later on. It's just that those things are aspirational in many respects, and we would like to see them happen. Now, with the papers that David sent me, there was a really brilliant paper looking at this issue that cited the Centre for Disability Justice. It is important that care commissioning decisions are based on evidence-led research and assessment on need and not on ideological considerations. When making commissioning decisions, we should place the individual's needs and preferences at the heart of the process and not the form of care in which these needs are met. Now, I've been sort of practicing and researching on social care law for 40 years, I suppose. And there are so many fads that come along and then keep coming back again when you get to my age. And the ones that get traction are the ones where they sound good and they also save the local authority money. And those are the ones that sort of get almost deified, that we're not doing this for any other reason than it's a principle. At the moment, I have a real beef with strength-based practice. Now, don't shoot me down, but that is used all the time to cut packages. I'm deeply concerned about this idea that everybody has to have a mandatory personal budget in England. The closure of all support that might be capable of being characterised as institutionalised. What does institution mean? It could scoop up pretty well everything. Why was that happening? Well, that was dogma, but it was also cost-cutting, I think. I think it also went with the grain. So that sort of homes, residential homes, bad, community, such an incredibly ambiguous word again. The Community Care Act, personalisation, they're sort of fluffy, beautiful words that are really hollowed out of all meanings when they are delivered in provision. And normal communities, good. Living in Ealing High Street, I'm going to come to, is good. But non-normal communities, i.e. not in the middle of London, are somehow bad. And so we come to this report, which I hadn't really looked at much before. I mean, I mentioned it, but I haven't critically analysed it. And I didn't realise Theresa Joyce was going to be following me to explain how this came about. But 2017 is the same year that the general comment came out from the CRPD, the Convention on the Rights of Persons with Disability, the same one that seemed to say anything that could have the faintest whiff of being an institution is a problem. And this report advocated small services and adopted the presumption that this meant usually accommodating 6 or fewer people. It then went on to say that it was not intending to be dogmatic. It didn't use the word dogmatic. It didn't want to be overly prescriptive. And it's not our intention to create a one-size-fits-all approach. It's lovely. You sort of have these sort of headline things, 6 or below, and then you have somewhere else saying, don't worry about this, it's okay. But that's exactly what happened. As the first tier tribunal said in that court case, it did become, the benchmark. Where that 6 came from, I have no idea. And I've spent quite a lot of time asking people similar sort of questions. Where does this point? I'm just doing something on incontinence, the law, curiously. So, yeah.
Taiwan.
Pardon?
Taiwan.
Taiwan.
And it was for 6 people who didn't actually say whether or not they were successful. In fact, most of them were not successful after 2 years.
I don't know if everybody heard that. We can blame Taiwan for this.
Nice guidance.
Nice software. I don't know what their social care system is. Probably very good. Yeah, so that's interesting. I mean, isn't that ridiculous? I think it also did. I think it was formed in quite part because of the emerging CRPD general comment. It's got nothing to do with domestic law. There's nothing in domestic law that talks about that at all. And then you have this sort of dogma that comes out, small, even 6 or fewer is bad. Anything that could come within this is bad. But you have these words, choice, autonomy, dignity, all of which, I should say that choice is not in the Care Act. It doesn't use that word. Autonomy and dignity, what are they? What is autonomy? There's probably 100 papers published in peer-reviewed journals by lawyers in England every year on what is autonomy. Hugely ambiguous word. And you add that to the dogma and you end up really where we are. I mean, I want to just say, I find choice a problematical term, very problematical term, not least because it appears as the main thing on every government document on social care law since neoliberalism came about. Choice, choice, choice. Not decent services, not quality, choice. Undoubtedly, choice has been incredibly powerful for many disabled people forced to live in institutions who had no choice about anything. And for me, a very privileged middle-class person who's never had that, it's wrong to denigrate choice. I think choice is hugely important, but it is a hugely ambiguous concept. It's a classic way the state can transfer risk to the individual. We're not going to give you a pension under the old system because that's patronizing, that's paternalistic. You go out and talk to these nice pension consultants and give them your money and you'll get a private pension. The state is in a much better position to make those choices than we are. And we go out and we're walking on very thin ice indeed. There are lots of things that the state is better at doing. It's very difficult for people to make choices that they don't make regularly. I know what I'm going to order when I go to a coffee shop. I know what I'm going to order when I have an ice cream. But when I encounter other issues that I've no experience about, how can I make choices? And of course, choices, the big issue is if I give you a bad choice or a very bad choice, I've satisfied the requirement of choice, but not quality. And one of the greatest books ever written in social care law is Richard Titmus's The Gift Relationship, which has just been reprinted, which is about the blood transfusion services, comparing countries where you do have a choice over blood and the UK, which you don't. There's only one blood service. And they're saying on that one, you don't want a choice, you just want decent blood if you're in a position. And he considers the market there. So choice is an ambiguous concept. I hesitate in this audience to say that because choice is only good if you have quality alternatives. Autonomy is the big problem with the committee's approach. The general view of autonomy, the sort of John Locke approach really, is it's me, 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 me. It's I do what I want to do. I don't think about anybody else. I just do what I want to do, and I have complete freedom to do what I want to do. And I'm going to buy a Porsche today, and I don't know what to do tomorrow. None of us in this room do that. Very, 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 very few people do that outside senior echelons of the United States in the moment. Most of us are deeply concerned about the impact it will have on other people, like the example David gave of the young man not wanting to go home because of it not being there, but also probably because of worry about his family and the impact it will have. We all make what we call these days a relational autonomy. We don't make individual decisions. The decisions we make are completely and utterly influenced by everybody around us on almost everything. And so this outmoded idea of individual autonomy, it goes very much to the heart of the UN's approach on this issue. And there's just a wonderful paper by one of my colleagues on this, Amanda Keeling. So that's a sort of general overview. We get this from an international document and Taiwan, and neither of those things could be referred to in legal proceedings. The CARE Act comes in 2014. There's a general duty under the CARE Act to promote well-being. Well-being isn't defined in the CARE Act, but it gives you some hints, and it's got that usual sort of list of issues. It doesn't mention choice, it talks about control, which academically is interesting, but in practice, those are the sort of things that we would all probably include in well-being. And then it gives you another set of hints, including the individual is best placed to judge their well-being. Even if they lack the capacity to make most decisions, many people will have preferences, choices, wishes and feelings. The Act really is very open-textured on how those needs are to be met. The old legislation said, care home, library, wireless, TV, telephone, personal assistance, adaptations. It had a long list, and it was all, do you go into this or that or the other pigeonhole? And the whole idea of the CARE Act is it's an open tableau, really, that you can do anything you like within reason, as long as it meets the identified social care need. It gives illustrative examples. There was a Court of Appeal case 2 or 3 years ago where Suffolk decided that it couldn't provide somebody with a holiday. And the Court of Appeal said, don't be silly. You can do anything under this Act if it addresses, it's a way of meeting somebody's needs. You can place them in any community if it meets their needs, their well-being, that list. And it doesn't offend any other laws. The list that I've just given you there of well-being doesn't include independent living, which is really naughty because the government made a promise when it ratified the UN Convention to do everything in its power to make sure those rights existed in the UK. And then 5 years later, it enacts legislation that is completely silent on one of the really core pillars. And I think we all agree with independent living in the way that we would interpret it, people living as independently as possible. So the government did some fancy footwork on that, and it said that the wellbeing principle, it's setting guidance, because the Act had already been approved by Parliament, is a core principle. I had a student recently do her PhD simply on what does independent mean. It's one of these deified words in neoliberalism, independent choice. Independent is meant to be free of any subsidy from the state, standing on your own 2 feet. Some of you are old enough to remember somebody said getting on your bike and looking for work. That's what independent means. Not for disabled people. For disabled people's movement and the UN, people become independent by having really good quality community-based supports. They have the personal assistance, they have the advocacy, they have the equipment that enables them to be on a platform where they then can live independently. And in a way, we can only live independently. We can't live absolutely independently. We can just maximize our ability to do those things. So again, this definition of independent is fine. It's as independently as possible. I just really want to finish, and then I think I've got some space. We can have discussion, which will be much more interesting for you. It's a case that I keep coming back to because I think it's a great case, and it was a judge that I admire a great deal. And it's a case, I don't know if you're all familiar with it, and if you are, I'm sure, like an old Dylan song, you won't mind hearing it again. So the facts are really very much along the lines that David was talking about, that all of you are aware. Although this man in his 40s, his behaviour was quite difficult to manage when he first appeared in this situation. He'd lived in a purpose-built, high-quality, bespoke service with 33 other residents in a rural location that was both safe and tranquil. It was a home farm trust type setting. He was one of 14 that went to court, but the judge decided to give the leading judgment on his situation because he wanted to stop the ridiculous costs that these cases run up. So he said, I'll give an administrative decision there, and then I want you all to go out, barristers, and have a think about this. And having given this judgment, the case settled for everybody else as well. So AH, his first name was Alan, had autism, was autistic, and had severe learning disabilities. He was non-verbal, highly distressed, very unsettled by moves, and had a lot of very difficult behaviours, including a form of pica that was very difficult to manage. He had an obsession with cigarette stubs and got very aroused if he was just brilliant at spotting them. So if he was in any situation where there might be cigarette stubs, he became very aroused and very difficult. And so that was quite difficult. And it was something that the community had not been managed to deal with. Many of these other obsessional attributes in other people they'd managed, but with him it was a particular problem. Keeping him away from roads and places where there would be stubs. But overall, and I think for so many of the people that I've dealt with, the need is for continuity, not to have changes in his routine or environment. And because he'd been in that placement for 10 years, his anxiety levels and his behaviour levels had all become much less of a challenge. He was even seen smiling, which really had never happened before. And that was uncontested evidence. If you want the case, I'll give you the links there. So, although this was in Hertfordshire, he was ordinary resident in Ealing, and Ealing proposed that he move to a secure flat in Ealing, which had a garden, and there would be sensors around where any movement could be picked up, and he would be sort of effectively watched. And he could even personalise his flat. This is somebody who has never experienced that sort of situation before, and all the evidence didn't suggest that was what he was in need of. It was accepted by Ealing that his needs were being well met where he was, and that there would be an immediate detrimental impact of any move. They used the word bereavement, but really nobody knew, well, people could predict what would happen. The only identifiable impetus for the move, in the judge's opinion, was the philosophy of valuing people and its message that too often adults do not get choices. And so the solution was to give him lots of choices about what he did in Ealing High Street. The workers in Ealing, the judge was very impressed by their zeal and their belief in valuing people. And I'm sure many of you remember that it was an amazing document when it came out. I remember going to lots of talks about it and thinking, this is really interesting. This is really a great initiative. Ealing accepted that it had never conducted a baseline exercise about whether it was in Alan's best interest to move or not. Its assessments had either been conducted on the assumption that he would one day have to move, or took the form of arguments justifying a decision they'd already taken. I mean, he really wasn't, he was a bystander in this process, as was his family, who were very involved in his well-being. So this is Mr. Justice Jackson, lovely, great judge. What the judgment says, and it is really worth reading, he said, look, care in the community, what does that mean? I mean, community care, when it came in, resulted in more people living in residential care than had been previously. And that was fine because there was nothing in care in the community that didn't say that. It was a nice word, but a nice phrase. While care in the community may not be without its problems, it is clear that many, perhaps most of those settled after lifetimes in long-stay hospitals have benefited. However, it's not an absolute policy, still less is there anything unlawful about campus living. He quoted the government's sort of assurances in the period leading up to these reforms. And the minister had emphasised the importance of showing that any decision is based on the overall best interests of the individual. The government are strongly committed to ensuring that people with a learning disability have a right to choose the kinds of services and accommodation they prefer. We also acknowledge that small-scale domestic accommodation can often provide a high quality of care. Such accommodation can offer more potential for social inclusion and enhanced rights. So the intention behind this initiative was well-meaning, and it was, I think, very well informed. And the judge went on to say, although Ealing's ambitions to maximise Alan's opportunities is laudable, it has not been possible to identify a single dependable benefit arising from the proposed move. The thesis is that it would provide him with greater experience of ordinary life in a local community, and this would improve his quality of life. Each element of this proposition is incongruous with the realities of AH's life. His experience so far is so far from being ordinary that it is not useful to use ordinariness as a yardstick. Ealing is not local for Alan, and there is no community there which would be meaningful for him. I accept the evidence that the prospect of him living a more expansive and fulfilled life following a move is a chimera. It may be likely that it would lead to a deterioration. Sorry, my dyslexia is coming out. It's more likely that it would lead to a deterioration from which he might or might not recover. It is not enough to say the benefits of community living may matter to him if one cannot show that they will. Facing up to these realities does not in any way diminish or demean Alan, but values and respects him for who he is. Guideline policies cannot be treated as universal solutions, nor should initiatives designed to personalise care and promote choice be applied to the opposite effect. These residents are not an anomaly simply because they are among the few remaining recipients of this style of social care. They might better be seen as a good example of the kind of personal planning that lies at the heart of the philosophy of care in the community. And that's where I'm going to end, really. I mean, that is a judge looking at the law through the lens of the English law. There is this background noise of guidance. Often we have no idea where aspects of that guidance came from. We have the background noise of a fairly new international convention that is still bedding down and is maturing and is facing some of these things that are not simple and linear, but they're complex. But when these things, when you can get it before a High Court judge, you end up with, I think, one of the really great judgments in this field today. So thank you for listening. Bless you all.